your evening with us. Thank you for everybody that has come and joined us online. Today we are really talking about coming together as a couple. So conscious coupling is the name of the event, and really this is really all about wealth transition. $1 trillion is scheduled to be passed down in the next 20 years from generation to generation. And with that comes a number of implications for individuals. So I know we have a number of parents in the room, we have a number of children in the room, we have, I say children, it's not really children, there might be adult children, you're probably in your 60s and your parents might be looking to inherit you some wealth. And one of the biggest questions that we always get as a family office is, how does this wealth transition impact my kids and grandkids? And as they get older, obviously they start to engage in adult relationships, and these are complicated, and they require very delicate and deft hands. So we're going to be talking all about how we can set up not only I'm going to use air quotes for kids, but kids and grandkids for success as we look to inherit that wealth down the family line. So I'm joined by my three esteemed panelists here. So on the far side, we have Alison Dennis, who is a family lawyer and litigator, as well as Debbie Jorgensen, who is an estate lawyer and litigator as well, and then our head of wealth planning, Alison Forster. So I'm going to ask them all to do just a quick introduction of themselves, and then we can get into the content. Also, a couple of quick housekeeping notes just before I do that. If you have any questions, please feel free to submit them online if you'd like. We're going to try and get to all of them, but invariably with the topic that we are discussing, they are incredibly personal and specific, so we might not be able to address them fully here. If you do have any very specific questions regarding your specific situation, please let us know. This is generally meant to be kind of a broad overview of what we're talking about. Please do not take anything that we say as specific legal, tax, or investment advice. Please do not take what we say and then go into willful. Please don't do that. These lovely people can talk about all of the pitfalls of doing that. We were just discussing it before, when people try and amend agreements themselves. It's not a good situation. That is the Coles Notes. So Alison, why don't you give us a quick introduction of you guys in the firm?
Hi everyone, I'm Alison Dennis, and I'm a partner at Dixon Appel, which is a estates and family firm in Midtown Toronto. So I practice primarily in the area of family law, so mostly related to separations, as well as planning for relationships like marriage contracts and cohabitation agreements.
Okay, it's working. Hi, I'm Debbie Jorgensen. I'm also a partner with Dixon Appel. My practice is in estates law, so I do estate planning, so preparation of wills, powers of attorney, trust documents, as well as estate administration, so advising executors or attorneys for property or personal care on how to act on behalf of someone else's estate.
And I'm Alison Forster. I'm the head of wealth planning services at the Rosedale Family Office and do all the wealth planning for our team and our clients.
Awesome. We have two Alisons here, so we're going to try and make sure we note the last name to not get too confusing. And really, I am your master of ceremonies for the evening. So the first question, kind of a bit of an introduction to the topic. From each of you, Alison, Dennis, I'm going to ask you to start, but what would you recommend for couples or, individuals that are looking to couple?
So I think it's hard for people to think of this when they're happy and in a relationship at the beginning, but I do like to have people think about what might happen in the event that their relationship does break down. We know this is very common. So especially if you're dealing with a lot of wealth or wealth disparity, or a situation where you're expecting to receive an inheritance or a gift during the marriage, it's prudent to think about what might happen in the event that that relationship breaks down. I also think that educating yourself about family law in general is important. The vast majority of people have no idea what the legal implications of a relationship are as far as what happens when you separate, in terms of the differences between marriage and common law, which I'll get into a little bit later, most people have no idea. They come into my office and I have to tell them for the very first time what's going to happen now that they're separated. So to avoid that, I think it would be prudent to meet with a family lawyer and talk about these things in advance.
Debbie, when you're thinking from an estate perspective, and people are getting together, I think that's something that's not really commonly thought of when you're coupling together. But from an estate perspective, what are some things and some pitfalls that you've seen when people are first getting together?
Yeah, so there's a couple of kind of different factors that would affect the estate planning advice that I would give to someone in a newer relationship or just a relationship that's become more serious. Alison's going to touch a bit later on the difference between being legally married versus common law and the legal implications of that, and that affects your estate planning as well. It changes things from an estate planning perspective significantly, whether you're legally married to someone or not. So certainly for everyone, regardless of the status of your relationship, I would recommend any adult should have a will, should have powers of attorney, should have this kind of planning in place. And it's not enough to have it in place once. It's something that is supposed to be revisited over and over again throughout your lifetime as you have children, as you acquire assets, as you receive inheritances, all of those, or to start a business. All of those things might factor into the planning that you want to do or that you ideally should do. And then from the incapacity side of things, like powers of attorney, a lot of people don't think, especially when they're younger, that applies to them, that they think, oh, that's something for when you're older and maybe experiencing cognitive decline. It's really something that should be there, right? Almost as soon as you are old enough to have your own bank account, you've got to start thinking about what if something happened to me, even temporarily, and planning for that and who you would want to be involved. And with all of these, aspects of estate planning, and I think family law as well, I think one of the deterrents for a lot of people is the cost of getting the advice, but the cost of not getting it. And, maybe you're playing the odds and saying, what are the chances that anything unexpected will happen to me? But if it does and you don't have the planning in place, the cost to the people that you leave behind is going to be much higher than what you would pay upfront to a lawyer or an accountant or, whomever you need to see to get the proper advice.
Alison, when you're doing wealth plans with our clients, what are some of the things that you would recommend for a new client, for a new couple that is coming together?
Well, not to sound like cliche, but open and honest communication, right? That's the basis for a great relationship. But in particular for finances, I think it's a topic many people avoid because it can be uncomfortable. But it's something I see play out day to day when I do wealth plans with our clients, right? You have to have those conversations, not only what are your assets, liabilities, income, but in the future, if you have parents that have wealth, is there an inheritance coming down, a business being sold, a property being sold, so that you and your partner have an understanding of what perhaps some planning you might need to do if you understand those assets and what your future looks like. I think with new couples, it's all great when you're renting an apartment, but then when you start buying the house, are you going to have kids? Are both spouses going to continue to work if you have kids? When do you want to retire? Those are all pieces that I think you need to talk about early on because that's going to be your life together in the future. So open and honest communication, I know it's cliche, but something that I do see play out every day.
No, it's very true. I think that's going to be kind of a common theme across, I think, all of our panelists is very open and honest communication amongst not only, I think there was sort of a stigma sometimes with the older generation where communication wasn't done, and we've kind of seen that play out. It's sort of ironic that they were sort of called the silent generation, but they really didn't communicate. And now we see that playing out, whether it's estates or in the family law realm quite a bit. So I think we were talking about this before, but there are a lot of misconceptions in both wealth planning, estate law, and family law. We watch a lot of movies, we see a lot of dramatic things play out, and we think that is how family law or estate law works. But what are some misconceptions that you see, Alison Forster, in the practice?
Thank you for saying my last name because I wasn't sure. There's so many misconceptions. I think, we can agree on that. So one that I do see is in regards to gifting. So we're looking at the scenario where parents might have some wealth and they're gifting to their kids. And I'm going to say adult kids at this point. But with that gifting, does that gift happen before you're married? Is it during marriage? And how is that gift gifted? Is it during a lifetime of a parent? Is it through a will, an insurance policy? And all of that kind of comes into play with what happens if there is a relationship breakdown. So, let's say it's before marriage and it's a gift coming into that marriage. Yes, that can be held separate, but if that gift is invested, that income, now that's part of the marriage once you get married, for example. But looking at gifts during the marriage, especially if that's kept separate, not commingled, that can be held separate, including that income coming off that property. So really what we look at with misconception is a gift, yes, if there's a marital breakdown, can be kept separate, but we really don't want that commingled. So I'm thinking, in my mind, a 30-year-old getting a bunch of money, where is that going? Most likely it's going to matrimonial home, into a mortgage, maybe a renovation, a joint bank account, and that's where it's harder to distinguish a gift, and that's where problems can happen, and a gift meant for a child can then be commingled. Marital breakdown, that might be divided in that case. So it's a big misconception with parents gifting and what they can do, what they can't do. And I know Debbie and Alison will probably talk about some planning that we can do in that case.
And it's a lot of parents that we're seeing in our practice these days are looking to inherit their wealth sooner. There was a lot of, I think again the silent generation sort of did it upon their death. When I'm dead, you'll be taken care of. But I think the mentality has shifted a lot, and now we're seeing gifts being done and things being passed along during the lifetime. Debbie, what are you seeing as a misconception in the estate law?
I think one of the big kind of misconceptions about estate planning is a lot of people think, well, if I have a will, then I'm done, right? But estate planning and proper, there are some places you can go and just get a will based on your instructions. But estate planning, is kind of so much more comprehensive than that, and involves a lot of different professionals potentially. Certainly for people with more complex assets, people with higher net worth, you're going to be talking to accountants and financial advisors. And there's a lot more to how you pass on wealth than just your will. There's beneficiary designations for registered assets. There's life insurance. There's joint ownership. There's all these different pieces, and an estate planning, ideally, an estate plan integrates them in a way that's the most efficient and effective to achieve your results. Part of the results you might be trying to achieve is tax planning, both income tax planning and probate planning. But that is, I would consider, kind of the tail of estate planning, and it shouldn't wag the dog, right? Ultimately, your goal should be who's going to receive this money or this asset, and if it means that to achieve that result, you've got to forego some tax advantages, then that should be the focus. So sometimes people get it a bit backwards, right? They're so focused on saving probate tax, and they try to put an asset joint with someone just to save probate tax, but it actually ruins their estate plan and who they want to receive from it. As far as lifetime gifting, definitely something we're seeing more of. A lot of people have that question about how to gift, pass on some of their assets. Obviously, the number one concern should be to make sure that you hold on to enough of your assets to make sure that you and spouse are comfortable and have all of your needs met. And that should be a bigger priority than trying to save some income tax or probate tax on death. But for those that are doing the gifting, especially to next generation, to children, they should be thinking about, what happens if I gift this and my spouse and my child is married and they separate? What happens then? How do I properly protect myself and them from that? And you see this, I see this a lot in the context of first-time home buyers, right? Parents are trying to help out their kids by giving them down payments. How do you paper that to protect it? You're getting into properly documenting it as a loan would probably be one possible recommendation. The other would be to properly document, for the child to properly document it in a marriage contract or another domestic agreement, and I think Alison will speak to that. So that's one area of concern. Another area of concern is if you have multiple children and you're gifting to them potentially differently, right? Some of them are getting a certain amount of money, others are getting another amount of money or a property. You want to make sure that the gift is properly documented as a gift, because there are lots of litigation. There's lots of litigation in cases involving, sadly, siblings fighting over whether parent intended to gift this or was just adding them to avoid probate tax. And so if there's no proper record of that, it can get pretty ugly between siblings once you're gone, right? So if you are intending to make a gift, that should be properly documented. Sometimes people are intending to avoid probate tax, and that should be properly documented as well to protect you and your kids, to say they're joint on title not because they get to just keep it, or they're joint on that bank account because I want them to have whatever's in there when I'm gone. They're there because it makes it easier for them following my death, but they have to share it with their siblings. So that's another area of concern. And lastly, a third area, as far as gifting to children differently during lifetime, there is a way to equalize that through your will. You can use your will and your estate to try to make it even between the kids if you gifted to them differently while you were alive. But it has to be, again, it's up to you to make sure that your wills properly set that out and make sure that the documentation behind the will, right? Your records actually track what was gifted, because again, that's another area for dispute between kids when their parents die is, no, that tuition that they paid for me, that wasn't part of what they wanted to equalize. They were just talking about down payments. Well, maybe the parents did want to equalize all of it, but is it properly recorded? So yeah, to kind of, summarize, I would say misconceptions would be, I think, kind of resting on, the will covers all of this. Estate planning is so much more than that, and ideally you're getting advice from all the professionals you need to make sure, and that they're working together to make sure that there's a proper plan in place.
No.
Alison?
Yes, so from a family law perspective, I think the most common misconception is probably the difference between being married and unmarried and the property rights that attach to both. I mean, marriage is becoming increasingly less common, so more people are choosing to be unmarried. And so only married spouses have automatic property rights under the Family Law Act. Unmarried spouses do not have automatic property rights. So married spouses have a right to an equalization of net family property, which is, to oversimplify a little bit, an assets minus debts calculation as of the date of separation, with a credit for anything that's brought into the marriage, less any debts that are brought into the marriage. And the difference between the two spouses' net family property is what is the amount that is equalized, so that each spouse has the same as of the date of separation. Common law spouses do not have a legislated right to property division, so they have to make equitable claims in order to have property rights. So they have to assert trust claims, resulting constructive trust claims against properties. They can allege that there was a joint family venture, and other kinds of unjust enrichment claims. And that's how they would acquire property rights if the assets are not registered in their name. So I think that in terms of the definition of property, Alison touched on the fact that gifts are excluded property if received during the marriage. So the Family Law Act provides for excluded property, which may be of some interest to people in this room who are thinking of gifting to the next generations. So gifts, inheritances, and life insurance received during the marriage are excluded property under the Family Law Act. However, if you receive those gifts prior to marriage, they're not excluded. They're just date of marriage deductions. So you get a credit for bringing that into the marriage, but any appreciation and growth will be equalized if there isn't a domestic contract providing otherwise. So a lot of domestic contracts have to do with dealing with these types of assets. You don't have to have a domestic contract. The contract's entirely out of the legislation, but you can have a domestic contract that just deals with a gift. Now, one of the things about gifts is that even if a gift is excluded properly, so the gift itself is excluded from a division of property under the Family Law Act, the income may not be, so the income may still be available for support purposes. So if you're gifting regular cash payments to a child to assist with the family, or you're paying for private school, or you're paying essentially regular amounts to a child, the asset itself, if there is an asset at the end, may not be available for equalization purposes, but the income that you're providing may be included in the spouse's income for support purposes. So that gift is not actually, entirely excluded as it may have been intended. And same too with if the gift is excluded, unless the testator who gave the gift also provides that the income received on the gift is also excluded. So if you're giving an asset and it's, let's say you give $500,000 to a child and they invest that asset and they earn an income on the asset, then the asset may be excluded, but unless the gift provides that the appreciation on the asset is also excluded, it won't be. So this is why careful drafting of gift documents and any kind of a situation where you're receiving money and investing it, it's better to have it well documented either by a domestic contractor or a properly drafted gift.
Can I actually jump in on a bit on that? Something that I see come up a lot from the estate planning side is a lot of people see this clause in their will that says, the gift is this gift to this beneficiary, typically, child is of the biggest concern. This gift to my child is excluded in the event that they and their spouse separate. So if they receive the inheritance from me while they're married and then they separate, the gift is excluded, they don't have to share that. But the warning I have to give to people all the time is that is contingent on your child keeping the gift separate. If the child commingles it with their spouse, if they add their spouse joint onto the asset, if they use that money to pay off a mortgage on their jointly owned home, right? There's a lot of ways that they could inadvertently commingle that asset, and then they will lose that exclusion. So, other than there's only a certain extent to which we can and to which we should want to control from beyond. But one of the things we can control when we're here is what education our children have. And so I always encourage people to educate their children about this fact. And, you could put in I'm going to hold it in a lifetime trust so that their spouse can never see that, but that might not be really how you want your kid to live, is to be beholden to a trustee and never have access to their own funds. So most people, I would say, don't do that. They gift outright, at least at a certain age, to their kids. But then I think it's kind of the onus is on the parents to help educate the children to even if they don't go into specific amounts, to let them know you're going to be receiving something significant from me, and there might be things that you want to do to protect yourself. And I'm not impugning your spouse or your relationship in any way. It's just, sensible to be fully informed before you make a decision about what you do with that money. And it might be that people who are educated about their choices tend to make better choices. So they might ultimately make a choice that you would disagree with, but at least they made an informed decision, right? So I really encourage people to encourage their kids to get advice before they decide what to do with their funds. And it might very well be that they kind of find a middle ground. They might keep some of it separate or preserved. They might end up using some of it for family needs. And it's also an opportunity for a family lawyer to enter the picture, to say it's, there's a lot of stigma around domestic agreements, I think, from TV and movies about, what it means to ask someone to sign a marriage contract or a prenup. But I encourage them a fair bit when it comes to inheritances, right? It's not saying, I don't want to use this. It's saying, I got this money and I would like to use it in a way that benefits our family, but I also want to know if we ever separate, that it's protected in some way, right? So a domestic agreement, and Alison, you can correct me if I'm wrong here. A domestic agreement could say, I'm going to use this inheritance in these ways that benefit us jointly, but if we ever separate, I'll still get my credit for the value of what I brought into this picture. So they could use it to pay off the mortgage, but it means that if they ever separate, they'll get more out of the sale of the home, right, to make up for that gift. So there are ways to do it. It might mean an uncomfortable conversation, but that's kind of what a lot of this does involve, right? Is that people do have to have these uncomfortable conversations with their kids or with each other about what their expectations are. So, am I right?
No, that's absolutely
you can
right.
Contract
and most
around
people
that?
do put their inheritance or their gifts from their family members into a matrimonial home where the exclusion is lost. And as I mentioned before, you can have a marriage contract anytime. It does not have to be before the marriage. It can be at any point during the marriage. It doesn't have to deal with all property. It can only deal with that one gift that you're receiving. I mean, marriage contracts are domestic contracts, cohabitation agreements, which apply to unmarried spouses, are very much sort of choose your own adventure as far as what you want to put in them. Some people want blanket exclusions of everything, which I can talk about a little bit, and the pitfalls of that. But you can really customize a contract like that to address your particular circumstances and to make sure that your spouse is being provided for to some degree or to the degree that you feel is fair given what you're receiving from a family member.
Sure.
So when you're talking about gifts and I think you're talking about cash or securities or something, do some of these same rules are being applied with real estate?
That's a great question. I think, we get that a lot and thank you just for the people that are online. I want to make sure that they also hear this because this is a great question and we do get this quite a bit. We are talking about gifts, and does that exclusively, when we're talking about the rights of gifts that you just mentioned, are we talking about cash only, or does this also apply potentially to property? Does this apply to art? Does this apply to, like, if you were to gift a company, corporate shares, all of those things? How do those apply?
It applies to any gifts.
Any gifts?
Any gifts.
Yeah, and I mean, I would say on like gifting real estate during lifetime, a very common one would be the cottage, right? Say at some point we're going to hand over the keys to the cottage to the kids, right? It's going to be theirs. So again, as between kids, especially if you've got multiple and only one is getting it, I definitely recommend that it be papered that you are gifting it to them. It is not an estate planning, probate planning vehicle for you. You intend for them to be the sole owner in their own name outright going forward. But again, that is an asset. A lot of people, I would say, and Alison, I'll let you jump in on this in a moment, but a cottage can be a matrimonial home for family law purposes. It doesn't have to be like a lot of people, I think this is a misconception on this subject. A lot of people think primary residence is the matrimonial home. There are special rules in family law about the matrimonial home. So that's another area where I definitely recommend people get family law advice, is if they themselves are already married or going to be married, they're bringing the home into the relationship, they already own it, and it's in their name. Just because title is solely in your name, once you marry, you're actually giving a certain amount of the equity in that and the rights in that property to spouse, and you can contract around that. The same is true for property. A lot of people think, well, I inherited the cottage. I received it from my dad's estate, and it's in my name only, so it's protected, right? It might not be. It might be that if you're using that as a family property and as an asset, your spouse might actually be getting certain rights into it, even though they're not on title. So again, that's where proper planning and education, I think, come into it as to whether or not a marriage contract or a domestic agreement is required to really truly protect it, or are there other avenues like trusts and whatnot that might be appropriate if you're really concerned about how it's handled. And kind of untied to that issue as well. And cottages, investment properties, these are all kind of, part of the same idea. If you're passing it on to kid and the intention is you don't want them to leave it to their spouse, right? You say, well, it's in your name now, but when you die, I don't want it to go to your spouse because who knows what might happen with them if you die first. They might remarry, right? I want it to stay in the family and go to my grandkids at the end of the day. Again, that's something that you have to plan for, and your child might have to plan for. And they might say, yeah, I'll put that in my will. I'll put that if I inherit this cottage from you, then it'll go down to my kids. But we have testamentary freedom in Canada. We have a fair bit of discretion, unlike certain, other countries, like in Europe, for example. A lot of them have forced heirship where it has to go to kids. In Canada, we can choose not to leave everything to spouse. We can choose not to leave everything to kids. But there are certain rights that spouses in particular have that if they're not met, spouse might have a claim against your estate. So you might say, I'm going to exclude this. I'm going to pass this on to my kids and cut spouse out of it. And it might work out, but it might actually be that spouse ends up having a claim against your estate. The only way to protect against that, again, really is a domestic contract where your spouse acknowledges, I'm not going to be getting certain assets when you die, and I agree that I can't claim anything as a result.
And I think that touches on another aspect that we wanted to get to, which is the inequality when spouses get together, because in many, many instances that we see in our practices, it's couples getting together, but there's inequality between the two of them in terms of their assets that they are both bringing to the table. And I would say it's probably actually more rare that people are equal when they're bringing assets together. There's automatically going to be inequality. Like if you had the exact dollar together when you got together, that would be actually pretty incredible. But really we see this all the time where one side of the family has certain types of assets they would like to pass down to their family. Another side has other assets that they're looking to pass down. Alison, what kind of planning points can you see when we're seeing this level of, asset inequality between two sides of the family?
Yeah, you're right. I think many of our clients are dealing with this, whether it's the clients themselves who are getting together where one has maybe a lot more assets or a much higher income we see often, or maybe our clients are the parents and now they're talking about passing gifts on to their kids who might be not clients or newer clients of ours. Before we kind of layer in the complexity, which will kind of get more complex as we go down the row here, is just to have your financial house in order, right? So I'm just to reiterate, to have your wills and powers of attorney updated, beneficiary designations in all your registered accounts. Make sure that it aligns with all your planning. It's a really simple thing, but something we see misaligned all the time. And that includes insurance policies as well. So insurance is a tool that we use, at Rosedale Family Office. And you think of insurance more as a risk management tool, right? So for a young couple getting together, we have to cover income replacement, mortgages, any debt. And especially if there's income inequality, if the high income earner or something happens, you want to make sure the spouse and possibly family as well are protected in that case. So, that's one scenario that we look at. But, with their clients who are older, passing money on to their kids, insurance is also a wealth management tool, right? You're able to redirect money from an investment account into an insurance policy. It grows tax-free. The death benefits paid out tax-free to your children, for example. And that's something that, as we've talked about here, if you keep that separate, don't commingle it, that's something that can be protected for your child. And so we've seen that actually quite a bit in our practice. But one something we haven't really talked about too much is blended families. So either, a second relationship, kids coming from a previous relationship, it's that question of, I want to take care of my new spouse, I want to make sure my kids are okay, but they're bringing in kids too, like how am I going to deal with this in my estate planning? And it's actually probably something you deal a lot with, Debbie, right? So insurance is something we've seen used as well for estate equalization, or not even equalization, but just an estate gift. So if there's a class of heirs that you want to get a specific dollar amount and the residue goes to, let's say, your new spouse through maybe a spousal trust and then to your kids, it's just an excellent tool to tax efficiently pass assets and just help you kind of organize your estate planning a bit better, because we're seeing blended families more and more often. And yeah, just essentially a great tool. But a question I have for you, Debbie, is A question we get a lot is about trust. And I don't even think clients really know what they're asking when they ask about trust. They say, I think I need a trust. What do you think? So how would you respond to that?
In the context of disparity between or like blended family situations?
It could be blended family or just a disparity in income. So one family is coming in with more assets, and they perhaps want to protect that for kind of their line.
Right. Yeah. I mean, so there's kind of different types of trusts, and a lot of people, hear it, or they say, oh, my accountant mentioned, or someone else I know has a trust. There's lifetime trusts that we set up for various reasons, and then there's trusts that we create through our will that will only kick in when we die, right? Those are testamentary trusts. So a lifetime trust, sometimes you see it in the context of an estate freeze when someone has corporate assets. You might see it where they create like a family trust, this discretionary trust for the purposes of kind of income splitting and getting some tax advantages using, passing on money to lower income beneficiaries that will be taxed less than they would if they kept the money themselves. So there's different ways that trusts can be used during our lifetime. Typically, if it's during lifetime, it's more of a tax planning vehicle than it is anything else. In a will, especially in a blended family situation or where there's a lot of disparity in wealth, we see trusts being used, sometimes spousal trusts, right? Surviving spouse is going to receive everything, but they don't just get to do whatever they want with it and then pass it on to whomever they want in their will. It's going to be held in this trust and used to make sure they're looked after. And there's a fair bit of flexibility and discretion to the testator as to what that looks like. Typically, to get the tax advantages of gifting to a spouse, all of the income in the trust has to go to the spouse, but you can dictate what happens to the capital, right? You can say, they're not allowed to touch any of the capital. I'm preserving that for my kids at the end of the day. Or they can get a certain amount if the income isn't enough to cover their needs, for example, right? There's different things that, and it can really be customized to, what your goals are. Is your concern really that they're not financially savvy and you want to make sure that its money is managed for them because they wouldn't know what to do, without it, without you there to be managing these things? Or is your goal to ensure that the assets and the value is really preserved for next generation? So it can really depend on what your goals are and what the family dynamics are, including the wealth disparity and what you would want to do there as far as whether you include a trust or not. And you can actually combine it. You can leave outright gifts to a surviving spouse, but then have certain assets held in trust. Where I see this a lot would be if there is capital assets, right? There's a business, and you don't necessarily want spouse to become the shareholder, but you want them to receive the income while they're alive, but the business is going to go to the kids at the end of the day, or your shares are going to go to the kids. You can provide for that as well. And again, this is kind of back to my point earlier about, are taxes, starting to dictate what your plan is? There are certain advantages to gifting to spouse, right? There can be a tax deferral or rollover, but otherwise that's going to be triggered on your death. But if you gift to spouse in a particular way, you can push that down the road, which can save your estate money, or at least delay when it has to be paid. So that kind of sometimes that desire to gift to spouse can sometimes run into the desire to preserve for children, and next generation trusts are often the way that you can achieve that, right? So that's part of the consideration. On kind of a different note, as far as having disparity in wealth between, I guess it's kind of related to the spousal trusts, having disparity in wealth between spouses and the concern, have I provided enough for surviving spouse? Because they might have claims under the Family Law Act, if you're legally married, to a certain amount. They are allowed to say, if you didn't leave me enough in your will, I'm allowed to claim under the Family Law Act and treat your death as a form of separation that triggers my right to equalization, right? So if you don't have a marriage contract and you said, oh, well, we understand she's going to leave money to her kids and I'm going to leave money to my kids. But if you don't have a marriage contract that actually crystallizes that, you won't be around to find out, but they might actually change their mind when you die, and it might not even be them. It might be their own kids or sibling that's acting as their attorney for property, saying, I've got to make this claim against deceased spouse's estate because they need the money for their care. So that's something to consider. Again, that's where trust can sometimes come in, is to try to thread that needle of providing for a lower income or a lower wealth spouse, but still protecting things. Aside from the family law election, they might also have a dependence claim. That's a separate. The family law election is about your property and asset and value. Dependence claim is about, do they have enough to live, right? And that's a different consideration. So both of these things, kind of are usually looked at. A lot of times people do come to a lawyer to advise on these things, depending on their circumstances, especially if it's a blended family, or if one spouse is going to be receiving a huge inheritance, for example, they're going to be receiving this big family business or something like that. It might not actually be appropriate for the same lawyer to advise both of them because their interests are so different. And to really get the advice they need to protect themselves, they might actually be advised to see each to see their own lawyer and to negotiate, what the estate plan is going to look like, to make sure that both of them are getting the proper advice.
So Debbie gets to deal with the constructive side of trusts. I get to deal with the back end where the couple separates and there's a dispute about who owns the trust property. So trusts are, like Debbie explained, a legal separation between trustee and beneficiary. So they're designed that way so that the trust property is no longer owned by the person who donated the trust property. It's legally owned by the trustee. And then the beneficiaries receive benefits according to the trust deed or in the discretion of the trustees. In family law, though, principles of equity are applied to this relationship. So it's not as cut and dry as, okay, the spouse no longer has legal title to the assets, so therefore they're not included in their net family property. The court will look at other indicia of whether or not the spouse has an interest in that property from an equity standpoint. So, for example, the court will look at how much control the beneficiary still retains over the trust. Do they receive, does the deed of trust require the trustees to pay funds out to the beneficiary? I mean, many of these trusts are set up with the good faith intention of transmitting wealth, right? And they're not really set up with the intention of a separation where the beneficiary loses all control over the trust property, right? Sometimes the settlor wants to take the control away from the beneficiary because perhaps they don't trust them to manage their own money, so they put the responsibility in the hands of the trustees legitimately, and therefore there may be legal separation that a spouse can stand on in the event of a separation from their spouse. But often the beneficiary does retain some control over the distribution. Sometimes the trustee and the beneficiary are the same person. So in situations like that, there's an analysis of many different factors that I probably don't have time to get into right now as far as how it is assessed. And then there's a determination of whether some or all of the trust property and income should be included in the spouse's property for the purposes of equalization. And sometimes there can be issues of exclusions with the trust as well, because trust property can also be gifts. But again, the gifts have to be clearly made during the marriage in order to qualify as gifts. And then you have the income from the trust, which under the child support guidelines, which are equally applicable to spousal support, income from a trust is still considered to be income for support purposes. So even if you have trust property that's considered to be separate and not available for equalization purposes or for property claims, the income from the trust may still be or will still be included in a spouse's income for support purposes if it's being received regularly and with some frequency and over a duration of time. So once again, if trusts are being established for the purposes of wealth transfer, the most prudent course of action is to make sure that these are dealt with by way of a domestic contract, so that first of all, they have to be disclosed to the other spouse, because if you don't disclose assets prior to the execution of a domestic contract and they're discovered later on, chances are your contract's not going to be worth the paper it's written on, and your contract's going to be set aside. So there has to be full disclosure of the trust and the assets of the trust, and then there would have to be a contract dealing with how that trust property is going to be dealt with in the event of separation. So best not to rely on the separate legal person or the separate legal person of the trustee beneficiary in respect of family law.
That was awesome. And a lot. So thank you guys both. It is a lot. I think that's part of with the conversation I think that we're having here today is these are not like light matters that we're talking about. These are in-depth, conscious conversations that you have to have with not only your partner but also potentially your kids, who are now adults, by the way. Like we say kids, but they could be in their 50s or 60s or 70s and have obviously their own opinions of the world. But we are calling them kids in this instance, but they are inheriting this wealth, and they need to be educated about it. We really want to talk about one of the things is cohabitation agreements or domestic agreements. That was one of the main topics that we had. We do only have about 10 minutes left because we have gotten so into the conversations here, which has been fantastic. But talking about domestic agreements, it's kind of a bit of a taboo. It's a tough conversation to have. Alison Dennis, I'm going to rely on you here as the family lawyer. In terms of the domestic agreements, what do you like to see when we're talking about them?
So, as I mentioned earlier, you can have a cohabitation agreement, which is an agreement between unmarried spouses. This automatically becomes a marriage contract if you marry, or you can have a marriage contract. It's called a marriage contract whether it's before or during the marriage. And again, it can deal with any number of issues related to the breakdown of the marriage, except really child support. You cannot really contract out of child support because it's considered to be the right of the child. People try to do things with child support in domestic contracts, but most often they're not successful. Because child support, again, is considered to be the right of the child. I think the main, and domestic contracts are frequently challenged, especially where there's considerable wealth, because especially if a spouse is sort of shut out in a domestic contract financially, it makes good sense to take a run at it to see if you can get something set aside, because otherwise you basically get nothing. And people aren't expecting that, or if they signed on for that at the beginning, they're not very happy with that at the end. So sometimes you'll see domestic contracts being challenged. A lot of domestic contracts are worthy of being challenged because they're poorly drafted, or the main reasons that the Family Law Act provides for reasons why domestic contracts can be set aside. The main ones are a lack of independent legal advice and failure to disclose assets in advance of signing the contract. I think lawyers are getting better at making sure that they cover these two things because of the number of contracts that have been set aside without those things in place. But you'd be surprised by the number of contracts that still do not have, because people don't want to pay for lawyers, or they don't want to pay the cost of having their assets valued and doing thorough disclosure. And the more assets that you have, or the more complicated they are, the more it costs to get this disclosure process completed. But the reality is that if you do separate and your contract is subject to challenge, you will have hoped that you have provided sufficient disclosure to the other party in advance of signing that contract, because if there's any confusion on their part, or it's not clear what they thought they were agreeing to at the time, the contract can be subject to challenge and to be set aside. There's another section of the family law that allows a court to set aside a provision for spousal support or a spousal support waiver in a domestic contract for a number of reasons. The main reason that you see these challenges is unconscionable circumstances. So the reasons I just talked about for setting aside a domestic contract are for lack of ILA or independent legal advice and disclosure, those are reasons that occur at the time of the signing of the contract. This type of challenge is the circumstances at the time of the separation. So are there unconscionable circumstances as well at the time of separation that lend the contract to be challenged on the basis of unconscionability? So this is one of the reasons why it's important to have a well-drafted agreement, because if you have a significant amount of wealth and your spouse has nothing, and your contract says that your spouse will get nothing at the end of the day, and 30 years go by and you have 5 children, and that contract's going to be subject to challenge because of the unconscionability of the circumstances at the time of the separation. I'm not saying they'll be successful. There's very mixed case law on the success of challenging domestic contracts, particularly if there was disclosure and independent legal advice. But you do want to sort of think about having a very one-sided contract or in terms of drafting a successful contract. So it's important to have experienced counsel who can advise you on exactly the terms of your contract to make sure that it holds up. And it's important to kind of spend the money that needs to be spent to make sure it's done right. It's a valuable agreement. It's really everything when it comes to governing your finances in the event of a breakdown of the relationship.
Debbie, what do you like to see in the will?
Yeah, I'll add in on that. I think what I said earlier about the idea that wills shouldn't be they're a point in time, right? And they may or may not be appropriate later on in life, depending on all sorts of different factors. So they are supposed to be something that you revisit time and time again. I think the same is true to some extent for domestic contracts. I've certainly seen on the estate planning side of things, someone come in and say, well, we have this domestic contract, but the domestic contract talked about a home that is no longer owned. They've sold it. It was previously in one spouse's name. They sold it. They bought a new place. It's now in both their names. It completely changes what the outcome will be upon death. And therefore the outcome on separation as well, because like I said, death can be treated as a form of separation to trigger certain family law rights. So I've definitely had people come, and also there is it's necessary to share it with your estate planner, right? Don't just say I have this document. They should see it because they really need to make sure that that it all blends, right? Because there might be certain rights that are granted in that document that are not going to be addressed in the will. There might be certain assets that are held jointly that are going to pass by right of survivorship that are not going to be referred to in the will, right? So it all kind of has to come to and dovetail together for it to work the way that you wanted it to. And with so many of these things, I mean, certainly with the separation agreement being set aside, you're probably alive to see that happen and to maybe kick yourself for not having done what you could have to make it more enforceable. But on the estate side of things, you're not going to be here to deal with the kind of mess that's been left. It's going to be your spouse or your second spouse or your kids, and they might all be fighting each other, right? So, and that's certainly, not what anyone wants. And the costs that are involved in that kind of litigation and dispute, like the financial cost, much less the personal cost to those involved, is so much higher than the cost it takes to give proper disclosure, to get a proper valuation, to go see, at least consult with a family lawyer, even if you decide not to proceed with any sort of agreement. At least you kind of done so consciously. So I think that's kind of what's been missing for a lot of people. Certainly, a lot of people I see is that there's a lot of assumptions about how things will happen, and there's a lot of assumption that people will get along, and assumptions that people will do the right thing or will honor their wishes, right? But there are things that you can actively do in respect of your own situation to make sure that it happens the way that you want it to. There are things you can do to educate your kids or your beneficiaries about things they can do to make sure that they're protecting themselves and your asset. Because, one of the other alternatives, certainly not so much for you if it's your domestic contract, but if it's your kids, or you're encouraging them to get it, what's the alternative that it was very common a couple of generations ago to have these lifetime trusts, right? There used to be different tax benefits to testamentary trusts, and so a lot of people were doing these trusts where kids never ever got the full value of their money. It was always protected. And there is some benefit to that. You can say, oh, well, then it's not exposed to a spouse or it's not exposed to a bad influence, But on the other hand, then your kids never get to be treated fully as adults. They never get to be responsible for themselves and their assets. So I think the better approach is definitely to educate them. People that are educated tend to make better decisions. So, it always comes back to that with a lot of these things, right? Your child can see a family lawyer when they get their inheritance, and they can listen to what they have to say, and they can decide for themselves, do I think I need this document or not? Ultimately we all kind of have to relinquish control at some point, I think, and it might be that sometimes they play the odds and they don't work out, but they also know your wishes, and I think will step up if you kind of give them the opportunity to take ownership of things like that. So, that would be the advice I have on those, is that people should kind of get past the stigma of domestic contracts and, is this impugning the relationship, and just be, very pragmatic and realistic about the fact that there are, we often think of them and talk about them as being one-sided, right? That it's, you're denying me something if we separate. But it can actually work both ways from spouses. It might be that one spouse is a very high earner and or is coming into the relationship with a gifted property, right? They bought their condo using money from their parents, and they want to make sure that when they get married, they still get credit for that gift if they ever separate. So the contract might initially have been prompted by that discussion, but it could also protect their spouse, because maybe their spouse is going to inherit a bunch of money, and that's also addressed in so it can be really a mutual discussion between people, and it also allows them to, especially if there's grandkids, right? If you're talking about gifting to your kids and you're thinking about their kids as well, right? Most spouses can come together and agree that we want to make sure that certain assets are preserved for our kids, regardless of what happens between, the two of us. So there can be a lot of common ground and a lot of satisfaction gained through those types of contracts in creating certainty, and everyone knows where they stand and everyone knows what's going to happen, instead of, a lot of people, feel very adrift about, what's going to happen if I die or if I separate, and not really knowing, what will come next. So they can create a lot of peace of mind.
And Alison Forster, I'll let you have the last word on domestic contracts and what, when we're putting together wealth plans for our clients, what are your sort of recommendations?
Well, during a wealth planning process, it's, if you have one, provided. So we can take a look through it, because it's going to affect our planning. If it's our cash flow planning, retirement planning, estate planning, insurance. So I think you made many great points, but making sure everything works together. And that's where I find a lot of holes in the work that I do, is you have a will, you have a domestic contract, you have this insurance policy, you have that asset, but nothing's speaking together, and that's when problems and litigation happens, and that's really what we're trying to avoid. And so that's something that we uncover, and then we bring in said experts to help us kind of bring everything back together. But making sure all your documents just speak together, are cohesive, and don't contradict each other really helps planning go a lot smoother in all these cases.
Thank you. And thank you all for the presentation. Thank you guys all for coming. We were going to try and do questions, but we've talked so much about these topics that we don't actually have time for them. If you are here, please feel free to approach us, and mostly not me, these lovely people to ask them questions about what we discussed today. One of the things that we talked about a lot is disclosure, and we hear it a lot when we're going through our wealth plans and we talk to people about their wills, and people turn to us and we say, you should have this conversation with their kids, and they say, they'll know. How? How are they going to know unless you tell them? If they read a will, it's a legal document. It's not a conversation that you've had with them about your intentions. So I think one of the biggest things that we talked about was disclosure, whether it's you're doing a cohabitation or prenuptial agreement, whether you're talking about your wills, whether you're talking about your intentions from beyond the grave. It's important to have the conversations in advance, and I think disclosure is probably the number one thing that I think you should take away from this. We talked about a lot of things. It's incredibly complicated, whether you're looking at estate law or family law, and we didn't even bring an accountant. Death, taxes, and divorce, and we didn't bring an accountant.
Taxes and probate planning, that's a big one.
Yeah, that we could have gone into, we did a whole thing on that. So when we're thinking about this, and if you haven't really brought your attention to it and you have questions, we are all available to answer them. So please submit something in online. And if you do want to come in and have a full wealth plan discovery with us, please reach out to us and definitely do that, because it's not only coordinations with people like Debbie and Allison. They are obviously huge parts of this conversation, but also with your other financial advisors, whether that be a business valuator, whether that be your controller, whether that be your accountant. These are all people that need to be coordinated and brought into the conversation in order for a wealth plan to really truly come to fruition properly.
Can I just add, do I have time to add one last thing?
Yes, for sure.
Okay, well, so on your point on disclosure, I would say, I think I would probably speak for Alison as well, one of the big problems that we see is people not knowing where everything is, right? So there's no point in having domestic contract if no one knows about it, right? Or if they discover it 3 years after they've already paid out your estate to the wrong people because your domestic contract said it was supposed to be dealt with a certain way, right? So it's important that you know where these documents are. Certainly same with your wills and your powers of attorney. You should know where they are. The people you've named to act for you in these documents should know where to find them. And if you move that, you should update them, right? Because I think and if there's professionals involved, it's always certainly nice to give contact information, but professionals retire or they move or they die, so you can't just rely on the fact that, they would know to contact my lawyer or whatnot. There should be, full disclosure to your kids. You don't have to tell them how much they're all getting. You don't have to give them a copy of the will so they can see, that their siblings getting credit for something or other. They don't necessarily have to see all that, but they should know that you have these documents and they should know where to find them.
No, that is a great point, especially as parents get older. I think the assumption is that we're always going to be fully cognizant of these documents, and when I'm in my 90s, I'm just going to whip out my will and give it to you right before I die. But odds are your cognitive capacity has declined dramatically, and you no longer know where these things are. No, you're still very sharp. So as a result, to your point, for a lot of our clients, actually, we create a full binder for them that actually has where everything is, who that individual is. I think Alison is going to start rolling it out to now our broad base of our clients, but where everything is, who are all the professionals, what is their contact information, because sadly that information sometimes is lost or put in a drawer and then never remembered. Until somebody is going through a drawer as you're moving out into a home or something like that, and then now it's not very helpful. So with that, I want to say I'm going to close off the event. Thank you guys all for coming. Thank you for attending online. We very much appreciate it. If you have any questions afterwards, please reach out to us. Hopefully you took something away from one of the conversations, and you're going to either have a conversation with yourself, have a conversation with your spouse or your kids about something that we talked about today. So thank you guys all so much for coming. We really appreciate it.